We are opening up the webinar. We'll give it a moment or two so all folks in the waiting room will be able to come in. So we'll start in about 60 seconds. Go. And welcome everybody to this town hall meeting of the Circuit Civil Judges in the 12th Judicial Circuit. Today is November 21st, 2024. We are recording this presentation. We are going to attempt to make it available after the event today on the bar websites as well as the court's website. We are, or actually Holly Lips from the Sarasota Bar has secured CLE credit for today, and the information for that will be displayed at the end of today's presentation. If for whatever reason you can't make the entirety of the presentation, you will be able to grab it, like I said, off of the court's website or the bar, and you'll just go to the end and there will be a slide that has the CLE information. And at this point, I'm going to go ahead and start a sharing of my screen for our presentation. You do have the ability to ask questions in the chat. The idea is we'll try to answer them at the conclusion of the presentation. My hope is that we can start answering questions around 12:50-ish, but we'll see how we're doing time-wise. It might be a little bit before that time. And there we go. So welcome to the Wind of Change, the revised rules of civil procedure. And again, it's important that you realize today is November 21st. And as we'll discuss, the rules that the Florida Supreme Court are not yet final. I checked before we started, and there was no changes as of earlier this morning. So this is effective January 1st, unless the Florida Supreme Court tells us otherwise. Today, we're going to go over 3 basic questions. How do we get here? And then actually, where is here? And probably most importantly, where do we go from here? And during today's presentation, my hope is we'll be able to answer all of those questions for you so that you have a comfort level with what we as a court will be doing starting January 1st of 2025. Now, let's get to how did we get here? And I want to take a moment and go back in time. This is pre-COVID time, but in 2019, the Chief Justice of Florida at the time, Chief Justice Kennedy, who is still on the Florida Supreme Court, created a work group on improved resolution of civil cases. And the task of this group was to review the totality of the civil case realm and make suggestions, whether it's rule-based suggestions, statute-based suggestions, policy-based suggestions. And this group met both before and during COVID. That group ultimately came up with a substantial plan with substantial changes to the rules. And you probably remember that huge 400-page tome that came out of the Florida Supreme Court during COVID. Ultimately, what occurred is during COVID, the Chief Justice entered a civil case management administrative order within one of his COVID orders. And those are basically the orders that we have been living with since 2021. You probably know we started doing the initial case managements, and we've been working on our increased civil case management for several years. And ultimately, the Florida Supreme Court, instead of adopting as one whole section, an entire rewrite of the civil rules, what they did is said, we're going to break this down into more bite-sized pieces. And in 2023, they asked the Florida Bar to look at a handful of rules and said, you have 6 months to look at these rules and come back with a rule change that addresses improved resolution of civil case management. Now, going back to the 2019 establishment of the work group, this was a charge. This was the biggest charge, and I've got it there. Florida's judicial branch is committed to continual improvement of the administration of justice, including the enhancement of civil case management processes in order to deliver justice in a timely, cost-efficient, and accountable manner while maintaining due process. So that's a big mouthful. We've kind of narrowed that down to this: go faster, cost less, but maintain due process. And this is the charge that we have received from the Florida Supreme Court from 2019. And as you might know, that is 5 years. And so while we are talking about these revised civil case management rules, in the minds of the Florida Supreme Court, they have been on this rewrite for 5 years now. And over the last couple of years, we've seen and we've known that this change is coming. And that's why we have been trying to start changing the course of how we handle civil cases so that it is not as, one day we're under one set of rules and the next day we're under a second set that are totally different. So we've been trying to change the culture advertently from the lawyers are driving the case to the trial judge is driving the case. So that is the 5-year ramp up to where is here. Well, here is May 23rd, 2024. There were 2 decisions released by the Florida Supreme Court that contain the new rules. And if you want to write those 2 cases down, it's actually worthwhile to go to the Florida Supreme Court website and read those 2 cases because it contains their thoughts as to what's going on, plus the revised rules. Now, as I indicated, these rules are not yet final. And in fact, there have been lots of comments that the Florida Supreme Court received after they released the May 23rd decisions. And they actually conducted a second oral argument on this, on these rule changes 2 weeks ago. And that's why I was looking this morning to see if they have issued any changes, but they haven't yet. I suspect, and this is just me, this is not official policy, this is nothing. I did watch the oral argument. I think they might tweak a thing here or there, but I do not think that there's going to be any substantial changes to it. Whether they delay implementation, maybe, but I doubt it. But we'll just have to wait and see what ultimately the Florida Supreme Court does with these rule changes. Now, let's start talking about what these changes are. And we don't have time to go over every single change. So we're trying to hit the highlights, those that we know that are going to impact your practice. And so let's start talking about them. There's going to be changes to discovery. There's going to be changes to your motion practice. There's going to be changes to how you handle summary judgments. There are substantial case management changes, and there's been a lot of discussion about trial continuances. So let's start breaking those down. Now, with respect to discovery, we're still operating under Rule 1.280, but this is a revised Rule 1.280. The very first thing that you're going to notice is there is now an initial discovery disclosure requirement. That is something that the federal courts have had for quite a while, but we are now going to have it here in Florida. And it's going to be due within 60 days of the lawsuit being filed unless the judge orders otherwise. Importantly, there is no discovery request that is needed. This is going to be an obligation that the practitioner will have to go ahead and actually address without any side prompting. Now, what is it that you're supposed to do? Well, Rule 1.280A talks about it. And in general, what you have to do is basically tell people, anybody that has information about the case, you've got to send along their contact. And this is any person that might be a subject for a claim or a defense. The next thing that you have to disclose is a description by category and location of documents, including ESI, the electronically stored information. You have to do a computation of damages. Now, this is one of those situations where there was a request that it be clarified to make it only economic damages, because it's probably very difficult in a personal injury case to quantify a non-economic damage. But when it comes to like missing work, medical bills, things like that, those economic damages are ascertainable and need to be turned over. Also, insurance policies have to be turned over. The next big substantive change is the duty to supplement or to correct. Again, this is something that is new in Florida. There is no requirement right now, unless a judge has entered it, to, once you file your discovery, you don't have to go back and when you learn something new, send that information over to the other side. That construct is changing. You will now be under an obligation to supplement or correct your discovery responses. Now, read the rule, because there's some discussions about, if you learn something in discovery and the other side has that same information, there might be some issues there. But as a general rule, you do have an obligation to supplement or to correct discovery. That also includes an obligation to supplement and correct your initial disclosures. So at the end of the day, the onus will now be on you as the lawyer to send over your side's information, and that will be an ongoing, continual obligation. Proportionality. This is now expressly written into the rule. Proportionality was a substantial discussion at the oral argument and also a substantial generator of comments before the Florida Supreme Court. on several fronts. One, there's a thought that this is just going to be another vehicle to actually slow things down and allow for objections. Some people think that there's no enforcement mechanism in it, and so there might now be a more detailed enforcement mechanism. I think from a more practical standpoint, I think it's going to play out just okay. It'll right now, proportionality is not expressly included in the rules, but there is some thought that they are implicitly considered in the rules already. So I'm not sure if those comments are going to really generate any changes, but we'll wait and see. The next significant discovery change is a detailed certification on any response and any objection, and it is very specific. I know we currently have had for a long time a requirement to have a certification and what used to be our local rules and our standards of professionalism. That is now substantially expounded upon. You have to have the certification. It's improper if you don't. It can be grounds for sanctions. So understand that when you do and send over an objection on discovery or send over a response, you're putting your bar card number on that response, and you are making a personal certification relative to what the rule is now requiring. So those are the highlights of our discovery changes. So let's talk for a few moments about the motion practice and the changes to our motion practice. First, there is now a very express requirement to have a meaningful conference before you file the motion. And we're not talking about a email sent at 10 a.m. in the morning saying, if I don't hear from you by 4 p.m., I'm filing this, and you're saying that you refuse to respond. You have to identify the mode of how you do it when you try to confer and what the specific outcome is. Again, very, very detailed. You have to include that detailed certification required by the rule. This, of course, is going to change how the timing of when you file motions and how and when you address the other side. This requirement applies to all motions except for a handful of them. The ones that you probably will see the most, there are others, but the ones that you will probably see the most have to do with injunctive relief relating to summary judgment, and for those motions to dismiss for failure to state a claim upon which relief can be granted. Also involuntary dismissals, but not all motions to dismiss are exempted from the rule. Let me say that again. Not all motions to dismiss are exempted from the rule. So please look at Rule 1.202A. That is a new rule for the list of those that do not require the certification. Now, I said summary judgment is changing. Let's talk first about what's not changing. Summary judgments can still be filed 20 days after the lawsuit is filed. That is in the current rule. That is not changing. Also, all of the rules about, hey, we don't have enough information, that process, that's not changing. The process that a court may grant summary judgment on its own, that process is not changing. What is changing is timing. The new rule says, and I just put the quotes there, The response in opposition is due no later than 60 days after service of the motion. 60 days after the service of the motion. That is markedly different than what the current rule-based is, which is at least 40 days before the time fixed for the hearing. So let's visualize that for a moment. If a summary judgment is filed on January 1st, for instance, you will now have an obligation to respond to that summary judgment no more than 60 days. And that's probably around March 2nd or 3rd, depending on whether there's a leap year. And why is that an obligation on you as opposed to waiting for the summary judgment motion to be set? Is a hearing going to be required under the new rule? I think the rule, well, I will tell you the two places that used to reference a hearing on a summary judgment motion have been eliminated. In other words, there is no longer a rule that says that there has to be a hearing. Now, I don't know personally what I am going to be doing. I know some judges have discussed maybe not setting hearings and addressing summary judgments, especially if there's no response on day 61. I don't know. That's one where you're just going to have to learn what each judge is going to do. I suspect you're still going to have a lot of summary judgment hearings, but under the rules, you no longer have a right to a hearing on a summary judgment. And if you don't file your response within that 60 days, the other existing summary judgment rules will be, you can be deemed to have agreed to the facts that the summary judgment movement has said, and the court can act summarily at that time. So if you remember nothing else about the changes to summary judgment, remember the change of the timing, that you have an obligation to respond within 60 days after service of the motion. Now, let's talk about some of the case management issues here. That rule 1.200 is completely rewritten. So just go back and read the new rule. It does not apply to small claim matters, some probate and trust matters, some summary proceedings, and some others, but those are the big ones that it doesn't apply to. It certainly applies to county civil. It does not apply to small claims. The requirement for track assignments, whether it's streamlined, general, or complex, they remain. They can be changed by motion. There's still a requirement. This is the same requirement that was in the 2021 administrative order that was entered during COVID, that the case management order has to have certain deadlines, and those now are rule-based deadlines. And the 18 months for jury trial, the 12 months for non-jury trials remains. That's the standard. But where you count the beginning of the 18 months and 12 months has changed or will be changing. You will now count from the earlier of 120 days after the filing of the lawsuit, or 30 days after the defense files any sort of response or actually service on the defendant. What that means is you're going to get a little bit more time than 18 months and a little bit more time than 12 months. Other big changes to case management. The at-issue rule is eliminated. It is no more. It is no longer going to be permissible to try to change your pleadings on the eve of trial and then use that as a basis to get a continuance for trial. The at-issue rule is eliminated and trials can be set as soon as the lawsuit is filed, but in no event, it has to be set before 120 days after filing or 30 days after service. So it must be entered no later than 4 months after the lawsuit is filed, but could be entered the day that the lawsuit is filed. Anytime there's a case management conference, the court can hear any motion except a summary judgment or evidentiary hearing. Let me say that again. At any case management conference, a court can hear any motion, any pending motion, except a summary judgment or evidentiary hearing. From a practice standpoint, when you ask somebody to cover, please don't ask them to cover 15 minutes before the hearing, because whoever is covering is going to have to be able to know what's going on in the case. This is a change. And so whenever there is a case management hearing, if you're not going to be there, if you're the primary person on the file, and you're not going to be there, you're going to have to make sure that whoever you're having cover that hearing knows what's going on in the case and what are the issues, and understand that other motions can and likely will be addressed at the case management conference. Also, any motion hearing can be converted into a case management conference. The rules also now say that our case management deadlines must be strictly enforced unless changed by court order. Now, when we talk about strict compliance, I know there's a lot of angst about whether there can be trial continuances. I have heard a lot of folks say there will be no more trial continuances. That's not exactly true. Yes, you can still get a trial continuance. However, when you ask for a trial continuance, you have to explain why. And it's not just a very vague, generalized statement. You have to give very specific information, steps that have been taken to avoid it, and when you think the case can be ready to go, and the steps that are going to be taken to make sure that if the court grants the continuance, you're going to get the next deadline met. Dilatory conduct that causes a trial continuance is now expressly sanctionable. Interestingly, the court will now have to explain why a case is being continued, whether it's in a written order or stated on the record. And the court is required to reset for the earliest date practicable, given the needs of the case and the resources of the court. My view of this is this will be done in consultation with the lawyers, as opposed to just a rolling, we're putting you on the next one. But I'm not going to sit here and say that some judges won't do that. I know some judges statewide are thinking that that's what they're going to do. But I suspect, at least here in our circuit, that we will have the lawyers help us come up with any sort of continued date. Also, expressly required, the judge has to explain what, if any, discovery is allowed. What that means is, if a trial gets continued, don't just assume that you're going to have open discovery. You might not get any discovery, or it might be limited. And that is something that is going to have to be a part of any order continuing a trial. Now, we've been talking a lot about what these new rules are going to be for the lawyers. There are some judicial accountability rules, and I'm going to turn this over to Judge Moreland for a couple of minutes to talk about those. Judge Moreland? And you're on mute, Judge Moreland.
Thank you. I just appreciate everybody being here, and of course, Hunter putting all the work together to put this so that we have it in a format that we can also, I think, do what we do in the 12th the best, which is communicate with one another when changes are occurring. And changes are occurring for everybody. They're not just making the life of the attorneys more complicated. They've made the life of the judges extremely more complicated. And if they seem stressed, it's because they have a right to be stressed. The eyes are much more on them. Let's face it, we've always had the responsibility to move cases and make sure their due process is not suffering as contemplated by the Constitution of the United States. But that idea that we're responsible for moving a cases has now been coupled with very close ordered observations. And why I say that is that as this was rolled out, it was clear that the case management rule came out and that something else was going to happen. They were giving the judges tools to move cases along. But now that they've given the judges the tools to move cases along, they expect them to move along. So what has happened? Well, the first thing is that we had the AO Supreme Court 2023-037, which went into play on March 31st of 2024. And there's two parts to that have impacted the judiciary. The first part, which was 2.215 G1 and A, one was not new. One was the judges have a responsibility to maintain a log, to make sure they're ruling within 60 days after they announce or an order or a judgment, and that it's completed within that 60 days. Coupled with that, they've always had the responsibility of reporting that to the chief judge if they're going to run afoul of that rule. That's always a sheepish conversation, at least from my perspective so far, is if a judge has to come to you and say, look, I'm going to have this I'm going to have this go past the 60-day mark. What did change was 2.215 G2. That is the part about the notice of pending action. And it has been robust. I know that might surprise some of you, but there has been notices of pending action filed in the 12th Judicial Circuit against judges. It's there for a reason. It's to notify the judge, so you're supposed to serve it on them. What I will say now is the judge is reporting to me if they are running afoul of the rule. I know that the attorneys are filing notices of pending action, letting us know. And in addition, I have the clerk's offices have all graciously, Karen Rushing, Nadia Daughtry, and Angel Calaniso are giving me a heads up every Monday of any notices of pending actions that have been filed against a judge. And the reason I bring that up is I have no problem with the rule. I don't think any of the judges have a problem with this rule on the idea that we should be accountable for the time. I'm just cautioning you because I'm telling you only 1% of the ones I have received are actually from hearings for which the judge has a rule pending that they from a hearing. The rest have all been from the one side or the other has filed a notice that the judge has not signed the referral to mediation. The judge has not filed a ruling on a discovery request that the judge never even knew about. So the idea is you're supposed to give the judge a fair warning by serving on that is pending. But more importantly, we haven't lost our professionalism where you can get on the phone and call the judge's chamber and say, you know, Judge, I had filed this and it hasn't been ruled on. Could you look at this? Because I think, like I said, less than 1% have been something from a hearing that was taking longer, and the other 99% have been things that have just been filed, and the judge would have had no idea that had been filed. The referral to mediation had been filed, nor that the notice pending has been filed. So as I indicate on that rule, what's happening is we're getting 3 notices now. The judge has to keep their own log The clerk's office is letting me know if there is a notice pending, and of course, you can do the notice pending. What I will tell you, the 12th has done when this rule came in, we were very proactive, understanding that this was going to be happening. Every judge, because of the work of Judge Carroll, as well as the ID department, has available to them a log that was created that will automatically populate, and they can it automatically populates and calculates the 60-day mark. So the judges can have their cases on there. They can eliminate it by putting the day that they ruled on it. But we have made that available. Now, some judges have so much more technology ability, and they prefer their own log. Judge Brewer is one of those. She has her own system, but every judge has the availability in the 12th, and that's kind of unusual compared to the other circuits throughout the state. The other thing I will tell you is, and I already have, I guess, is that the clerk's office is being very cooperative and trying to make sure that we're kept informed if one of these notices are filed. Part 2 of what changed with the court order, the Supreme Court AO, was the time standards. I'm not going to belabor it. Hunter went over what has changed, which is the start date. But the dates, the timeline for the complex cases, other jury trials, non-jury, and small claims cases has not changed. It's just more, when are we going to start it? What has also unnerved judges is that not only do I have to file a quarterly report on all the cases, and this is across all divisions. The pending action is across all divisions. So under 2.250B1, I'm filing quarterly reports. It has to be filed the last business, the 15th day of the first month following each quarter. And that I have to serve on the Chief Justice. And the Chief Justice is told this. I give him a list of every case that is exceeding the time standards. Those are the ones that you saw in 2.250A1B. In addition, I have to list all the following information: every case, the case number, the type of case it is, in other words, what division is in, the case status, if it's active or inactive, which is a challenge in and of itself for the 12th Judicial Circuit because of not having that ability to collect that information off the clerk's site. If it's a criminal case, I have to let them know the date of arrest, and I have to let them know the original filing date in every civil action. What is new is annual reports, and that's 2.250B2, and it's only in civil. And what is now being required is that at the last business day of July, because this is on almost everything with the state courts is on a fiscal year. So the last business day of July, I have to serve the Chief Justice and OSCA, Office of State Court Administration, a status on every general civil case. It's county or circuit cases. And this is the information that has never been required before and gives you an idea how microscopic they're looking at the judges. I have to group the cases by county and circuit. I have to tell them every division that case is lying in. I have to tell them the judge that is assigned by name. I have to tell them that it's been pending more than 3 years since the complaint was filed. Section 2 goes on to require me, so I'll have to file that first report in no later than the last business day of 2025. In 2026, whoever the chief judge is going to have to file a double I that says I have to put all that information on there again. But this time we have to note if the case is still with the previous judge, I mean appeared on the previous report, and whether it has the same judge or a different judge. And then the triple I is there an active case management order? That's a lot of deep and in-depth information that every judge is going to have on their shoulders. And then I'm the person that has to do the report saying that. And the idea is that they're going to dig down. They're not going to anymore. They're not staying at a bird's eye view. They want a case view of why the cases are stalling. And that's humbly what they're going to be doing. The other thing I have to do is I have to notify them if there's no movement and whether it's on inactive or active status. And the reason why that's problematic, I referenced before, is because with our present systems used by the clerk's office, there is not an automatic way of knowing if a case is inactive or active. Why is that important? Case goes on inactive status, the time standard stops. It tolls the time that goes towards that time standard. It's only during the active time. In other words, the time the judge can have control and hands-on with the case. So what did the Supreme Court do? They passed these new rules and then said, all right, trial court performance and accountability, you need to monitor it for the next year. Well, good or bad, I'm the chair of that committee. And what I've been charged with doing is not only watching my own particular judges, but now I'm going in and I'm charged under AOSC 2447 with making sure that we discuss the following areas: inactive time, the reporting periods, the invocation of civil rules and small claims cases, and the use of the case management rules. And that report has to be done on December 31st of 2025. I guess the only thing I would leave you with on that part is that as the judges are moving these cases along, this kind of gives you the backstory of why they're feeling the need to push also, is because they're also being pushed and herded in the same direction you are. The last part is on the slide, you'll see the maintenance of practice and procedures on the websites. Well, the Judicial Management Council was charged with overseeing. They had done a study across the state, making phone calls anonymously to judge chambers, going on our websites, looking to see is there becoming an obstruction to justice by policies of the judges. In other words, do judges require a handwritten letter is one of the examples before they could even before someone could schedule something on their schedule something. The certain judges require every single thing to go through their office as opposed to having an automated calendaring system. They did this study through a work group and they came out with a report. And in that report, they said, okay, one of the things that will help this and for their ability to cull together the information in the future is that they have required us to have new practice and procedures on our websites. They have highlighted 10 things that should be highlighted and look the same on every single judge's page of requirements. And they have to be ADA compliant. In the 12th Judicial Circuit, seeing that this was coming along, we immediately started exploring how this would look. We had, I'm trying to remember, I think it was Judge Carroll, Judge Sniffen, Judge Inman were charged with putting together what ours will look like. So as we go forward, you'll be seeing that the practice and procedures of all the judges will become. The practices and procedures themselves may be somewhat different between judges, but finding the information will be more user-friendly on our websites. And I think that takes care of everything for me. And I thank you for your time, and please understand the judges' positions when they're moving these cases along.
Okay. Thank you, Chief Judge Moreland. So let's go to where are we going to go from here? Now that we've talked about the background and what the new rules are, what are we going to do here in the 12th? And all of the judges have been working together to come up with a plan. Our plan has the following core concepts. One, obviously, we have to comply with the new rules. We are trying very hard to be as consistent throughout the circuit as is possible. And that becomes, and this is a little bit of inside baseball, but every single county, we have different systems that measures different things. We can have an entire discussion as to why that is, but it just is what we have to work with. So we have to use whatever available resources that we have, even if they are uneven, but we're still trying to keep it as consistent as possible, even with uneven resources. We are doing our best to figure out how we can increase efficiency throughout the entire life of that lawsuit without sacrificing that due process and the adjudicative function. And so we can still put our time and effort on the adjudicative side of the world. And we know one size does not fit all, whether it is a personal injury case, whether it's a construction litigation, whether it's a foreclosure, whether it's a breach of contract. Everything's a little bit different. We understand that, but a lawsuit is still a lawsuit. So what is our plan? When a lawsuit is filed, you will expect to see a case management and trial order that will come out within a few days after the lawsuit is filed. Whoever the plaintiff is going to have an obligation as defendants appear to go ahead and serve that trial order on the defendants as they appear, and then put a notice of service in the court file. We are going to have standard deadlines for each trial period. So if we're going to be entering a trial order within the first few days of a lawsuit being filed, we're going to have those standard deadlines for that trial period. For those that have been going to the initial case management conferences, those will be no more. We won't have those to tell you to go ahead and get with the other side to create your own deadlines. We're going to give you deadlines. Yes, you can change those deadlines. You can do it by motion, but for probably 70 or 80% of the time, we anticipate that those standard deadlines will be sufficient for the case. Now, if you do complex commercial litigation, construction defects, obviously that's not going to be for you. But yes, you can change those deadlines by motion. You can't just agree amongst the lawyers. Trial periods. We talked about the 18 months really now has a little more time. So you can anticipate, depending on judge, a jury trial will be scheduled approximately 20 to 22 months after the lawsuit is filed. Non-juries will be 14 to 16 months, and foreclosures will probably be about 7 months. So that is the beginning of the plan. And as I said, I think it's going to work, or we think it's going to work in about 70 to 80%. What we as judges want to see: early use of case management conferences, especially in the following. If you think the trial is going to go more than 1 week, if there's a lot of electronic discovery, ESI, if you want to impose the case or designate the case as complex, if you're challenging the constitutionality of a statute, if you think the case is going to need above average judicial attention, whether it's the nature of the case or the nature of your opponent, let us know earlier than later. Let us come in and help referee those types of situations. And certainly, if there's anything particularly unique about the case, please come in for a case management conference early. The next big change that you need to be aware is when you file those motions. We talked about how there has to be a certification. What we are trying to do in this circuit, and again, we've got the uneven resources, so this is perhaps somewhat aspirational, but I think we're going to be able to pull it off, is if you don't have that certification or it's an insufficient certification, motion's going to be denied summarily. If you did not confer, if that certification says I called on such and such date and didn't get a call back, and I sent an email on such and such date. I sent, a text on this such and such date to this person, and no one responded. You can expect a show cause order, and you can have to explain why sanctions should not be given. This entire process requires a lot of work on the front end on the motions. And so when you are filing the motion, like I said, don't just assume at 10 o'clock you can email it over to the other side and say, if I haven't heard from you by 4 o'clock today, that I'm going to say that you wouldn't respond. That's insufficient. That will lead to a summary denial of the motion. Also, we're trying to find those contested hearings, those contested motions. They cannot sit. Summary judgments, they have that special 6-month issue, but contested motions that you want to set for hearing need to be set quickly. Our orders are going to allow the judge, if those hearings are not set within 21 days, you can get a summary denial. Doesn't mean that the hearing has to occur within 21 days, but you got 3 weeks to get the hearing set. That should be plenty of time after the motion is filed. You already know it's contested, so you don't have to wait to the other side whether they're going to contest the motion. What we want to see happen is we want to have less hearings and less canceled hearings. As you know, we double and triple book already. For us to prepare, it costs us time. And when we prepare and then a hearing gets canceled, you might think, oh, you now have that 15 minutes. But we've lost the prep time, and a 15-minute cancellation when you have things double and triple book doesn't help us. It doesn't make us more efficient. So the process for it to work, we need to have less motions actually go to hearing. So you've got to actually have those conversations ahead of time. And again, we don't want motions lingering. Now, pro tip, you would not know this unless a judge has explained this to you. Our proposed orders come through the portal in most instances. And as you know, you have to have a cover letter with the portal. Most people assume, rightfully, that the moment you submit an order through the portal, it automatically gets docketed. That is not the case. Depending on which county it is, it might take close to a week for that motion to be docketed. We're working on that issue, but that's beyond our control. So the pro tip here, let's say you have an agreed order and you want a judge to enter an order on it. With your cover letter, submit the motion that has the portal stamp on it so we know it's actually been filed, because it might not be docketed yet. And we don't want to have to hold orders until it physically gets docketed to see what the motion is. So if you give us the motion with the portal stamp on it, we will be able to address that more quickly. Further items with our plan. Obviously, we talked about initial disclosures and supplementing. We are very much trying to get discovery cutoffs further in time away from discovery. No more of this coming at docket side and say, Judge, I need to take these 2 more depositions. We want to end that. I think you want to end that. So please know that we are advertently trying to allow for time from the time of the discovery cutoff period for you to actually prepare for trial, knowing what the actual witnesses are going to say and not have to worry about taking additional discovery depositions, on the eve of trial or even during trial. So our goals under our plan: let's complete discovery earlier. Let's have more time for dispositive motions to be heard and resolved. Get those done a little bit earlier as well. and no discovery immediately before trial. We know this is a lot to dump on you. As Chief Judge Moreland said, we're under obligations too, and we're going to have to move these cases. We're trying our best. If this process becomes unworkable in certain aspects, please tell us. We don't profess to have every single answer. And some of this is going to be trial and error. But we think, we've spent a lot of time, the judges, we've had several meetings on this to kind of talk through how this is going to work in PI cases and in breach of contract cases and construction, and all the different types of hearings that we have here. So what I'm going to do is I'm going to open it up to see if any of the judges have some observations, and then we're going to get to your questions. And so I'm going to go ahead and stop sharing for now. I will come back and share the CLE certification at the end. So we're going to stop that. There we go. So is there any, Judge Nicholas, any comments?
Yeah, just briefly, I saw that there were a lot of questions. We're going to address them as many as we can, but it may be that we have to come back and do another one of these. They're challenging to set up, I know, but there was a lot of questions, and I hope we'll be able to address all of them here this afternoon. But just 2 quick points. I think the first is obvious, hopefully, although perhaps the 12th Circuit is a little bit more proactive with regard to these rule changes. We did not initiate them. I repeat, we did not initiate them. This is just a continuing series of directives out of Tallahassee for whatever reason, where it appears to me that the Supreme Court is eager that the state court civil system look a lot like the federal system. And there's significant changes. We get that. What is my point? My point is, don't shoot the messenger or messengers here. We're just trying to be as proactive we can and recognize the significance of these changes. Secondly, importantly, we understand that they're significant. And I may be the outlier here, but I thought that the at issue notice was fine. I thought the system worked fine, wherein you tell us when your case is ready for trial and how many days that you need, but that's not the system anymore. My point is, we recognize that there's significant changes and there's going to be an adjustment period. I would just suggest the use of the case management conference in those situations wherein there really is information that we need, information to help you process your case more efficiently. As Hunter said, we suspect that in about 70% of the cases, the initial trial order will be fine. But we get it. There may be instances where there's a wedding, where there's surgery, where there's a conflict, and the date that we select may not be the date that works for you. So don't hesitate to use the case management conference process and keep us in the loop. 30% of the cases is a lot, wherein that trial date may not work. We recognize that, but we'll work with you as best that we can. That's all I had to say. 2 quick points. Anybody else?
Were you trying to say something there?
Hello?
Judge Brewer?
Yes. Okay. I was just going to say that with regard to Judge Moreland's points, have no fear on reaching out to our offices to say, hey, gently nudging that there is a pending order. I know I can speak for myself, and I'm probably not speaking out of turn for any of my colleagues to say that we are really, really, really busy right now with the change to summary judgment. Summary judgment orders are no longer what they used to be. And if we are providing all of you what the rule provides, which is a thorough review of the record before us and entry of summary judgment when appropriate, it requires an amount of time in order to write that. We don't have clerks, unfortunately, which is one of the things that the federal system has that we don't. So while we want to be accountable, and I can speak for all of us to say that we are accountable, we stress about that 60-day deadline. If we're getting close to it or past it, just know that we have the chief judge knows, number one, and number two, that there's not going to be any, flogging over you emailing our office or calling our office to say, hey, is judge going to do that? It's just a nice thing to do, so that we can know, sometimes mistakes happen and things fall off of a 60-day log. Sometimes the case may have closed and we think it's closed, but in reality, it's not. If you would do that, that would be really a nice thing. Just wanted to add to that.
Anyone else wish to chime in before we get to some of these questions?
Are you ready for me to talk about the questions?
Right. Yes,
Okay.
please.
Okay, so first question is from an anonymous attendee. It says, will initial disclosures apply to small claims cases as well with discovery being incorporated into small claims where both sides are represented by counsel? And Hunter, if you want to take that one as to the applicability of small claims cases.
Well, I know that the small claims are, let me see if I can look at the rule real quick, are not part of this case management requirements. Let's see.
I think one of the,
A2.
and maybe Judge Moreland would be able to help out with that one as well because of the applicability of invocation of the discovery rules in small claims. Judge Moreland, did you want to add?
Actually, Judge Bird says proceedings exempt from initial discovery disclosure unless ordered by the court. Actions and claims listed in Rule 1.200A are exempt. And then when you go back to 1.200A, that lists small claims. So it would seem that small claims are exempt from that.
Unless there's an order wherein the small claims, wherein civil rules have been, is that your?
Yeah, that's what I was going to say. That's become a huge debate, and that's one of the reasons why we're being charged with it. Is attorneys are more and more, not so much in the 12th, but in the bigger circuits, demanding the institution of the civil rules of procedure. And so that's going to be the question: does that suddenly change it back then out of that exemptions category and move it over to the discovery mandated?
Speaking as a former county judge with the small claims cases, invocation of the civil rules is not necessarily as good as it may seem. So the small claims rules, while you may be very, very comfortable with the Florida Rules of Civil Procedure, which is really great, you may want to become more comfortable with the small claims rules because they have some different requirements that allow for speedy resolution. The next question I answered in the chat because it was a quick answer. Next one is, will motions not set for hearing or filed on the eve of CMC, and they're talking in terms of summary judgment motions, be entered even if the non-moving party has not had an opportunity to file a written response? Hunter, do you want to take it?
Okay, I guess I'm not seeing the question, but has the 60 days elapsed or not?
No.
Well, if the 60 days has not elapsed, I don't see how the court can entertain the motion unless there's an agreement. And
that's I would agree on that as well. If you don't have you have to file your summary judgment motion 60 days in advance. Does anybody else have anything to add? Judge Walker, Judge Nicholas, Judge Felix, magistrates?
I think the question was asking more in terms of any motion being able to be heard at a CMC. We're saying if it wasn't previously set, or even if the motion was filed the night before, are the individual judges still going to consider those fair game for a CMC?
You may be right. You may be right, Bradley. I think the reason why I thought it was in summary judgment is because it came in at the time of that question came in when he was talking about summary judgment. So
my understanding of the rule is that judges may hear anything at CMC. So if it's a situation where something's filed before, it's going to be unfair to hear it unless there's some type of agreement.
And besides, if you file it the night before, odds are it's not even going to be docketed anyway, and we won't be able to see it.
That's another really good point. I think a lot of people believe that that we're getting these orders or these motions directly to our emails, but we're not. And a lot of times they're not in our files either yet. The next question is, does the computation of economic damages required in initial disclosures include futures? I think that's all up for grabs right now. That's my understanding, is that that was one of the big questions at oral argument.
Right. I'll read to you what the rule says. A computation for each category of damages claimed by the disclosing party and a copy of the documents or other evidentiary material, unless privileged or protected from disclosure, on which each computation is based. So the rule says computation for each category of damages claimed by the disclosing party. So I think that's going to have to be fleshed out over time by case law.
Okay, the next is this recording? Oh, I've already answered that one. Sorry about that. Talking about sanctions, this was in the context of when we were talking about sanctions, Hunter. The question is sanctionable to party or to attorney personally? And my opinion on that is both.
I was going to say yes to both,
Yes.
depending on the situation. Because there can be times where the lawyer is trying to get their client to do stuff and the client just absolutely refuses. And there's times that it's the conduct of the lawyer that is causing the problem. And I think there was a second DCA decision, was it last week or 2 weeks ago, that kind of reminded the difference between when you're sanctioning a party versus sanctioning an attorney. So there's different standards there, but I think the answer to the question is yes to both.
I would agree. The next question is, will these rules apply to cases that are already pending as of January 1st or only cases that are filed after January 1st? And my opinion is that it's a procedural rule. And so therefore, currently filed cases, they will also apply. Anybody disagree on that? Everybody agrees. Okay, next question. Will or can the summons form be modified to address the initial disclosure requirements, particularly for pro se litigants? I think what that's asking for is, can we create a form for the different summons?
That's a great idea.
I think so too.
I think for those folks, and this might be a Judge Moreland issue for her TCPA committee, is that might be something that would be very helpful.
We will add that to our to-do list. Thank you so much, anonymous attendee, for the question. Next is, if the rules apply to all pending cases, will us as practitioners have a deadline supplement? And I am planning on doing deadline supplements for cases that are currently set for initial case management that do not already have a approved case management report, approved by a case management order. That is my plan.
I haven't gotten there yet, so.
Okay. And then they answered deadline to supplement discovery. I plan on doing it. And I think that that's a per judge decision to do. If the civil cover sheet includes an exemption outlined in 1.200A, will this negate the case track assignment and need for a case management order? For example, a petition in eminent domain.
Here's what we have. When I say we have case managers, we have a couple of folks that will be helping all of the circuit civil judges and all of the county civil judges. So it's not like we each have our own case manager, but one thing they're going to be looking for is looking at the civil cover sheet to, if it says X, Y, or Z, this is the trial order. If it is on the exempted list, we're going to probably just create a case management date for that hearing or for that case. So yes, we're going to be looking at, if we make a mistake, just let us know, say, hey, this is a summary case that we don't need to have this case management order entered in.
And remember, we are utilizing case managers to help us with some of these case management order tasks. The case managers, while they have been around the legal system a lot, they are not lawyers. So we're doing trainings as much as we can, but you just have to let us know if we get it wrong. The next question, Magistrate Ellis answered, but just so that I can say it out loud for everybody who's not necessarily looking at all of the questions. The question was, will there be instructions for getting hearing times if there are no dates available within 20 days of a filing with regard to the contested? And Magistrate Ellis indicated, and I believe he's correct here, as far as I'm concerned, the requirement will be to get a hearing set within 21 days, not to actually have the hearing occur within the 21 days, excuse me. Next question, we have any advice for meaningful conferrals with hostile opposing counsel you typically want to confer with in writing? Good luck. 57105. Kidding.
No, this is, and remember, if you're having a difficulty with the lawyer on the other side, please set a case management conference. You can always come in and say, Judge, hey, we've been trying to have some conferrals, but we seem to have some difficulty. You don't need to throw the other side under the bus, but ask the judge to kind of get involved a little bit. The judge is going to understand what you're saying, and we'll try to weed through that. I can't promise you we'll be successful, but we can try. But please if you're actually having difficulties, please set those hearings. And also in your conferral, if to call you back, they're refusing to answer your text, you detail all of that, and then let us issue the show cause order and let them explain to us why they didn't respond to you.
Also, we will become aware if there are habitual offenders. And there will be a way to deal with that as well, if need be.
All right. Next question. On a breach of contract claim for property damages, does public adjuster estimate count as actual damages? I think that's one that we need to skip as members of the judiciary right now. That's just my ethical observation. Next, to clarify, is this applying to active cases? Again, my reading of this is that this is a procedure. These are all procedural rules that will apply retroactively to cases that are currently in the system. And I think no one disagreed with that. Last chance for questions to put in the chat.
Let me,
We've answered all the others.
this is when you only have one screen, it makes it difficult. Let me go ahead and get the CLE information. Let me.
We have an additional question here. I understand with regard to Magistrate Ellis's response to the 21 days. We have a response. I understand, but at times there are simply no dates available for months that can be located, but mover still is required to have the motion set within the time period, not to be heard within that time period. Sorry for the confusion. On those instances, my policy is you would need to reach out to the judicial assistant to indicate that you've made meaningful efforts to get it set.
We did have one more question come in. It says, can we utilize paralegals in assisting on meet and conferrals?
That's a good one.
I don't know. I haven't thought about that one yet.
It's a great question.
I'm not sure I'd feel comfortable answering because, we're only going to see if it's either opposed or an insufficient. I'm not sure I can answer that one right this second.
I think it also depends on the type of motion. If we're talking about getting how to logistically send discovery, that's a different thing than if we're actually dealing with a intricate legal issue.
If it's go ahead.
Go ahead. Sorry,
It's going to rise to the level of bringing it to our attention that you're not able to successfully confer. I don't think under those circumstances you can rely on just your paralegal. If your paralegal is able to do an effective job with that, then maybe that's going to be fine. But if it's going to fall apart, don't rely on just the efforts of your paralegal on a meet and confer before it, that you're going to raise an issue with us. That's going to require active efforts by the attorney.
Yeah, because if the paralegal is actually effective, then we would never see it to begin with.
Exactly.
Judge Moreland, Jason and Laura Gaskell said that they would be happy to serve on any committee to address a proposed change to the form. So if you need volunteers, they would like to be put on the list. Let's see, any others? I think, oh, we got one more. Can you please clarify how the rules can apply retroactively to cases that have been pending for multiple years? For example, a motion for summary judgment submitted in 2022, but not set for hearing. These are procedural rules. Procedural rules do not relate to substantive rights, so therefore they apply retroactively. I know that there are going to be judges in the state of Florida, but not necessarily in our circuit, that as of January 1, if there is not a response, that they are planning on ruling on non-responded to summary judgment motions. I do not know, I can't speak for all of my colleagues because I haven't talked to all of them directly on that. I do not know that any of us will be doing that. That being said, if you have a summary judgment motion that you have filed in 2022 and it has not had a response, I would say that by 60 days into 2025, that the responder needs to respond, because I think that it's wide open for judges to be able to rule on those without the necessity of a hearing. To be clear on the summary judgment hearing requirement, my reading and Judge Carroll's reading, and I believe I don't know that any of the other judges disagrees with this. The hearing has been removed from the rule, so we can choose to have a hearing, but we can also choose to rule without one.
Yeah, I think all practitioners as a CYA, if there is a pending motion for summary judgment and you are the opposite side, you're not the movement, you're on the other side, you're going to either want to have your response in no more than 60 days after January 1st, or take those steps within the rule that would ask for a delay. I think you probably should be doing that.
And that's going to be 1.510D. There was a question for summary judgment. What about if discovery is still outstanding and being coordinated, such as depositions being set out past the deadline? Is a request for extension of time to respond to the motion appropriate for consideration? Well, that really isn't a necessity, because Rule 1.510D specifically says if discovery is outstanding and you cannot oppose a fact because of specific reasons, requires an affidavit or a declaration, and then at that point in time, the judge can act accordingly. The next question is, will disclosures be retroactive as well? Disclosures are procedural rules, so procedural rules apply retroactively. Next is the practitioner still expected to set a summary judgment hearing, or will the judges provide guidance as to whether they will rule on the papers or with a hearing? How will we know? I think that is dependent on the judge.
For me, people should still set hearings. You'll know if I'm going to rule without the hearing, but odds are it's probably going to be after a hearing.
I agree. So
I agree as well.
Go ahead and set the hearing, and then I'll cancel your hearing if I'm not going to hear it. Hunter, you want to give it?
Is there anything else? Because I know we're about over
No.
time at this point, and we really appreciate this opportunity to talk with you. Sorry, we're not like sitting live, but with over 100 and something folks online, this I think has been a good way of trying to get this information out. We do know that these are big changes. And certainly we understand that life happens. So don't feel like, hey, you've got your kids moving into college, or don't feel like your life has to end because of these things. But the takeaway is, please think through how these new rules will impact how you practice and how you set up your office, because you will have to change some of your processes within your office to accommodate these new rules. So please think through how they're going to impact you. And thank you very much for your time. On the screen has the information. We're going to get this put up on the 12th Judicial Circuit website. We'll send it over to the Manatee Bar and the Sarasota County Bar Association. And I think they'll probably be put up on those websites as well. Might take us several days to get it put up, but we will get it put up soon.
And Hunter, we've also had a request for just the slideshow as well. I think that we can do that separately, if I'm not mistaken. We can put both up.
If it can, well,
We will
let me
try our
talk to the
darndest.
IT folks, but we'll figure something out. But obviously, the slideshow has been within this presentation.
Right.
Anything else from any of the judges?
Thank you, Hunter, for putting it together. I appreciate it.
Thank you all for your time. And at this point, have a good afternoon. I'm going to stop the recording and stop the presentation. Have a good day.